not sure about the time, but normally then you are supposed to be given some 3 minutes to be able to make the representation. We will manage it as we move forward. Order, honorable members, order.
Thanks,
You know,
Chair.
I mean, one thing for sure, we can't have the whole day of speaking.
Yeah, no.
And that is not the intention, and that's why I'm saying is when it comes to representation, always a member is given 3 minutes to make representation. Okay, Honorable Malema is on the floor.
Thanks, Chairperson. The rule of 3 minutes applies there in the House. In the committee, normally people speak unlimitedly. Thanks very much for the opportunity, Chair. We have come here as members of the Parliament representing the economic freedom fighters, the economic emancipation movement, which is the 3rd largest political party in South Africa. We are appearing before this committee because the Speaker of Parliament has, through the Secretary of Parliament, preferred charges on members of the EFF, citing misconduct as a basis of all the charges which our members have received. This committee is supposed to prefer charges on members of Parliament, but we have it on good authority that after the appointment of the initiator, this committee did not sit to consider the charges, and members of this committee are seeing the charges for the first time. What kind of a judge can appear before a committee before they are familiar with the charges that are going to be tabled against accused people? What justice are we pursuing here? We are of a view that this committee should not proceed with the disciplinary process which we intend to embark on, because as members of opposition, opposing political parties, you are all conflicted and are in no position to arrive at a fair and just conclusion. Majority of you in this committee are members of the ANC, which from the 21st of August has been calling for harshest sentence against members of the EFF in response to the developments of the 21st of August 2014. To remind you, on the 21st of August, we asked the President of the Republic of South Africa, Jacob Zuma, as to when is he going to pay back the money as prescribed by the remedial actions which the Public Protector correctly and constitutionally said should be implemented by all parties involved in the illegal and corrupt construction of the private residence of the President in Nkandla. It is a common cause that there was illegality and corruption in the construction of the private residence, and this matter will be settled by courts of law since the President is refusing to pay back the money as directed by the Public Protector. On the said date, we ask the question of when the President will pay back the money, because it is our considered view that he should pay back the money. No one in South Africa is above the law, and the President is therefore obliged to pay back the money. When we did so, the Speaker of Parliament refused as an opportunity to receive answer from the President and continued to recognize other members of Parliament to ask further questions, despite the fact that our question was not answered. Chairperson, would like to draw your attention to the fact that there is a difference between response and an answer. And what Jacob Zuma did on the said date was to respond to the question and fail to answer the simple question of when will he pay back the money. We therefore request that this committee pays attention to the following realities. When members of the EFF rose on point of orders and asked for the attention of the Speaker of Parliament, she bluntly ignored them and instructed them to sit down. Under no occasion or circumstances did members of EFF defy the Speaker, despite the reality that she did not mention any member by name. She recurrently said that members who are not serious should leave the House, basically suggesting that members of EFF were not serious in asking the questions of when will the President pay back the money. The Speaker then suspended the House and ordered the Sergeant at Arms to remove members who she said were not serious. Now, on that question, we want to put it on record that all members of EFF are serious and were serious on the said date. The Speaker suspended the House for a few minutes and said she's doing so in order to allow members of the EFF to be removed. She specifically said that the House is suspended for 3 minutes. As a party leader, I then called the EFF honorable members for a caucus as all other members of parliament from other parties were leaving the house. They, EFF members, stayed back, received directives from the whippery now that the house has been suspended. Members of the ANC were seen and heard singing Mshinwam, trying to intimidate EFF members for holding the president to answer the question asked. Once outside, ANC members tried to force their way into the house such that it would have been dangerous for EFF members to leave the house. One member who successfully pushed a way in is Nokukanya Mthembu, seated amongst you, and a judge in a matter. She is not only a potential witness or witnessed the alleged misconduct, but herself sang the song Umshinwam and forced her way inside the house during house suspension, trampling over police line and successfully pushing police officers away to gain entry. All members in this committee are not only witnesses to the alleged misconduct. You actively participated in the singing of Mshinwam song inside the house as it was suspended. All members of this committee are not only potential witnesses to the defense, but you actually witnessed the alleged misconduct. Notwithstanding you witnessing the alleged misconduct, you are comfortable to be judges in a matter where you will witness the alleged misconduct. It is tried in law that a person who witnessed a conduct which conduct ends up in court where the witness is a judge and the judge cannot preside in that matter. In your determination to trample over principle of natural justice, you are not apologetic to insist that you be judges over a matter that involves the whole party membership in a house business, robust debate, and holding the executive accountable. The complainant is your party boss, and any suggestion to differ with her will be career limiting. The complainant is not only a speaker, but a party national chairperson who on Monday sits with the president and on Thursday attends the ruling party caucus and on other days preside over house meetings where she is expected to be impartial. Complainant is not only a speaker, but sits in the powerful deployment committee about who becomes a whip, a minister, and committee chairperson. It will be limiting for you to differ with her. The complainant is based on matters on the Nkandla Gate and the president. You are aware that your Secretary General has instructed you not only to protect the president, but to deal harshly with members of EFF who humiliated and embarrassed the president. Gwede Mantashe is not ordinary person. He's a secretary of the ruling party and he attends your party caucus together with the speaker every Thursday. He made this statement from Monday meetings of the top 6 that included President Jacob Zuma. The complainant is the national chairperson of the ruling party. In your majority year, you are members of the majority party and decisions in this committee are based on the majority rule. So you represent the complainant, you represent the subject of the complainant. President Zuma, you represent Gwede Mantashe. You are the witnesses, you are the complainant, you are the prosecutor, you are the judge and the jury. You see nothing wrong in your conflicting roles, It is a threat in law that you cannot be a judge in your own matter. You are so determined that the basic tenets of common law and natural justice makes no sense in your compromised, conflicted role. You cannot wait to hold the whole opposition before the royal ruling party to account for holding your president accountable and insisting that your national chairperson should allow the president to answer. It is unprecedented that all members of the opposition are held before a ruling party to beg for mercy and pardon. Several letters have been sent to you to consider alternative dispute resolution of this political matter because this is not ordinary misconduct. You have ignored those letters. You have been written a letter to consider removing other members who are not only perceived biased but are clearly biased. You have ignored the letter. Since neither your common sense nor the courts can resolve this conflicted role you are in, you are at liberty to do as you wish, but continue to judge as conflicted as you are. You are aware, but you chose to ignore the fact that complainant never called any of our members by name, each of them to move out of the house, and they refused. She referred to members who are not serious, and EFF members were very serious. It is practice and conviction in Parliament that members who must go out by directive of the Speaker should have his name called in terms of Rule 53.4. None of the EFF members were named. This committee is ignoring that. I've had an opportunity to watch the video of the proceedings, and surprisingly, you only charged 20 members out of 25 in attendance. None of the EFF members stepped out of the House prior to the suspension of the House and after it was suspended. As to what informs you in not charging them can only be explained by yourself. It is not clear who decided who must be charged. Is it the Speaker, the committee, or the prosecutor? It is the firm belief of the EFF that charges, once drawn up, they would have been discussed by the committee before being served to accused members. As to why the committee decided as such can only be explained by uncontrollable ambition to quickly find EFF members guilty at all costs by hook or crook. Complainant, the Speaker, had been made to withdraw her threat to tabling to the House a recommendation for suspension of members. She knew very well in that since EFF is accused of misconduct involving the president of the ruling party, the House majority, which is the ruling party, will so vote for suspension. The humiliation and embarrassment the ruling party wants to inflict to EFF knows no bounds. The rules and the Act never anticipated that this committee for once will deal with such a grave matter of the president refusing to account and the Speaker will protect the president. Never was it in the mind of the framers of the Act that the rules that a whole opposition party will be held before the ruling party to beg for forgiveness and mercy. The rules and the law cannot accordingly be invoked blindly because it was never intended to be so then. Such a scenario as this of today was never anticipated. It will be unconstitutional to hold the whole opposition before a committee before a committee whose majority are from the ruling party for disciplinary hearing. A multi-party democracy and existence of the opposition will perpetually be at the beck and whims of the majority party. The electoral system of South Africa is not constituency based, but members of parliament are deployed to parliament at the pleasure of the party leadership and expected to toe the party line unfailingly. Party and its top leadership have spoken on how this matter should be handled and concluded. The president of the ruling party, the secretary general of the ruling party, the national chairperson of the ruling party have spoken in public on what should happen. It will be career limiting and suicidal for this committee to act otherwise. EFF cannot assist the committee to legitimize the wishes of Lituli House. You are hell-bent to finish the little humanity and soul remaining of us after all insult hurled on us at the House by members of your party who will never for once ever appear before you for such a crude insult. What justice and fairness should EFF expect in a process where the judge is the ANC, the complainant is the ANC, the witness is the ANC, the prosecutor is the ANC, the House decision maker is ANC? You may as well hold this hearing at Lituli House. EFF has all the merits of the case and will have proceeded successfully on this matter before impartial jury. Just to remind you once more, after the suspension of the House, the Sergeant-at-Arms approached the EFF members of Parliament. It was when the House was suspended when members of the EFF started to chant, "Pay back the money." And in the process of chanting "pay back the money," the Speaker said, "Apia mapoisa," asking, where are the police? The committee should note and know that all our members are charged with chanting "pay back the money," which is a development that happened when the House was suspended. We are quite sure that the Speaker is aware more than all of us, and this committee is aware that you cannot apply the rules of a House sitting even when it is suspended. Members of Parliament have in previous occasion chanted and sang even when the House was in session. Members of the ANC have on several occasions sang Mshinwam during the sitting of the House and were never subjected to any disciplinary process. As she said during a city press gathering recently, the Speaker of National Assembly lost it on that day. And we cannot, as members of EFF, be subjected to a disciplinary process because of a Speaker who admitted publicly that she lost it. The Speaker not only said she lost it, she continued to attack members of EFF, referring them as young people that provide excitement in the House. She is quoted and can be heard on video footage that we have where she says, in the video footage that we have, where she says, I will tell you about 21st August, when Zuma fielded questions, where I thought I lost it that day. All right, it's out there. I cannot deny, but it's wrong to reduce the cause of what went on that day to the Speaker. The charge which we're expected to answer here does not hold water and does not deserve our attention. The Speaker ordered members to leave the House so that Amapoisa could come to physically remove members of the EFF from Parliament. Unfortunately, police did not come. Instead, later, the House resumed peacefully. Members of Parliament of the ANC, two of whom are members of this committee, Honorable Lozipo and Honorable Nogukanya Mtembu, forced their way back into the chambers with an intention and threats that will physically assault members of the EFF. Yet today they are judges in a matter of their own. The ANC caucus here in Parliament and in Litule House issued a statement calling for highest actions against members of the EFF. Now we are expected to come here and appear before an ANC committee which has already taken a decision of what should happen. In the events post 21st of August 2014, the Speaker wrote a letter to members of EFF asking them to write justification on why we should not suspend them for days varying from 17 to 14 days without hearing and suspension without pay. In doing so, the Speaker violated section of the powers, privileges and immunities of Parliamentary and Provincial Legislature Act, which says it is illegal to threaten a member with withdrawal of any benefits enjoyed by members of Parliament. Section 7E of the Act provides that no person may deprive a member of any benefit on account of members' conduct in Parliament or House or committee, and accordingly it is and was illegal for the Speaker to threaten to suspend members without pay prior to a due process. On the 2nd of September 2014, the Speaker addressed the National Assembly and made very problematic statement, also misled the House on the development of the 21st August 2014, where she said, let me state that at no point did I call the Public Order Police Unit during events of 21st August. I cannot but strongly condemn the disruption of proceedings in the chamber and the manner in which this impeded the House's ability to conduct and conclude its business. Security was called upon to assist the Sergeant-at-Arms when members continued their refusal to leave the chamber in complete and open defiance of the chair. On Tuesday, 26 August, I made a statement to inform the House that the matter was being referred to the Powers and Privileges Committee for the committee to investigate whether the conduct of members involved in a disruptive actions constitute contempt of Parliament in terms of the powers and privileges and immunities of Parliament and Provincial Legislatures Act of 2004. I further informed the House that while the matter was before the committee, I was also considering the implementation of Section 10 of the Schedule to the rules which makes provision for the suspension of members where the allegations against them are of a very serious nature. She claimed that she never called the police into Parliament, despite her recorded call when she said, "Api amapoisa." She made rulings that EFF disrupted Parliament, despite the fact that a committee was set up to investigate whether there was disruption of Parliament. It is our considered view that the Speaker should be the one who appears before this committee because, in her own admission, she lost it on the 21st of August 2014. It is our considered view that the Speaker should appear before this committee because she disrupted the proceedings of the House on the 21st of August 2014. Instead of recognizing members of EFF who were rising on the point of order, she suspended the House and called on police to come and remove members of Parliament from the House. It is our considered view that Baleka Mbete should appear before this committee because she made illegal threats to members of the EFF. It is our considered view that Baleka Mbete should appear before this committee because she misled Parliament in claiming that she did not call the police while she's on record saying, "Api amapoisa." It is our considered view that Baleka Mbete should be charged because the House collapsed due to a lack of patience and leadership, as she concedes that I lost it. How can we be subjected to events that were caused by the Speaker who lost it? Now this committee is under no position to proceed in a fair and just process because all of you who are members of this committee were in one or another involved in the developments of 21st of August 2014. Some of you here even tried to physically confront members of the EFF and forced your way into the House with an intention of physically removing members from the House. This committee is under no position to engage in a fair process because of you are employees of the ANC who are here primarily to carry forward the directives of the ANC, and the ANC has already said what should happen. The complainant in this case is the ANC, and the members who preside over this case are ANC members. So already the principle of natural justice has been compromised. We do not want to waste our time engaging in fruitless process which have already been decided in Lituli House. One thing we want to remind you though is that we are not employees of the ANC and we are not employees of any of you here. We were employed on the 7th of May 2014 by more than 1 million voters. Those are the people who will hold us accountable and not a puppet committee which works under the instructions of Gwede Mantashe, the Secretary General of the ruling party. And we want to remind you that in terms of Section 13(5)(g) of Powers and Privileges Act, the highest sentence you can impose on us is suspension for 30 days without pay. And further, Section 13(9) provides that such can only be considered after all other sentences in subsection 5A to E have been considered. The other sentences are as follows: A, a formal warning; B, a reprimand; C, an order to apologize to Parliament or the House or any person in a manner determined by the House; D, withholding for a specified period of members' right to use or enjoyment of any specified facilities provided to members of Parliament; E, a fine not exceeding the equivalent of 1 month's salary and allowances. We are therefore here to make the following concrete recommendation. 1, stop the entire process because it is contaminated process with the ANC acting as a complainant, judge, and will possibly be witness if the case proceed. The committee should table to the House concerning the decision to withdraw the charges. The committee should summon the Speaker to caution her against the manner in which she conducted herself in the House on the said date. Whatever the outcome of this process, Chairperson, the EFF will not be participating. Thank you.
Thank you, Honorable Malema. The last statement you have made, you say whatever the outcome of this process, the EFF will not be participating. I'm not sure whether that actually gives any meaning or any clarity to your proposals. I'm not sure whether you can clarify that, because I don't know where it fits in the process.
Chairperson, we are not going to be subjected to you and your ANC colleagues, and we have given reasons why. And we are saying to you, if you decide to proceed, you can proceed on your own. We are not party to this.
Okay.
Because this is an illegitimate, unconstitutional process.
I got
and
the
we reserve our rights.
Okay, thanks. I got the clarity. Honorable members, yes, Honorable Mdagan.
And EFF not participating,
Order.
I mean the charged members.
Order, Malema. Order, Honorable Malema. The floor is for Honorable Mdagane now.
Sure. I think then we are going to have the presentation. The presentation that we should have. And but also just to say, we are members of parliament mandated by the rules to do what we are doing. And then we're not mandated by another person, we are mandated by the parliament because we are members of parliament. And then parliament has the rules that guide its own operation. We are doing this and then entirely in terms of the rules of parliament. And I think, Chair, we should then allow the committee to have again a small meeting and then to decide what we to go forward with the issue that we are doing.
Okay. Okay, thank you for that input. Now,
Chair.
be orderly, honorable members. I think also what we need to correct, I think, honorable members, is that the Powers and Privileges Committee is not an ANC committee, it's a multi-party committee. Now, order members. It must be made clear that it is a multi-party committee.
On a point
Thank you very much.
On a point of order, Chair.
And order.
Chair, on a point of order.
Order.
We've made
Order, Honorable Malema.
No, but I'm calling a point of order on you, Chair.
I want to finish what I'm saying.
No, but you can't finish when I'm raising a point of order.
Honorable Malema, just give me an opportunity to finish what I'm saying.
Can you recognize me on a point of order?
Remember that, Honorable Malema, I did what I could do, giving you almost 30 minutes to present.
But you're not doing me a favor. You are not doing me a favor.
Not necessarily.
Never think you're doing me a favor.
But what I'm saying is that...
you must never think you're doing me a favor for listening to me.
Yes.
You charged me and you are going to listen to me. You didn't charge me to come and tell me you're doing me a favor. If you didn't want to listen for 30 minutes, you should not have charged me.
Order, Honorable Malema.
Chairperson.
Order, Honorable Malema.
Chairperson, I request you not to respond because...
Order. That's correct, yes.
Yeah, don't respond. You are going to confuse this House.
Order, Honorable Member. The proposal has been made for the committee to have an opportunity to reflect and to reflect on the matter. The presentation that has been made, as it has been indicated in the beginning, that currently there is no rule that talks to this specific activity, then the committee must talk to it, and also would like to request a copy of that specific presentation, the hard copy, so that the committee is able to speak from the document that has been made. And Honorable Malema.
Chairperson, we've got copies of what I was reading here, and I think our business with you ends here. Whether you are going to have a meeting or not, we have no role to play. We are leaving. All right, thank you.
Give me the copy.